A number of states in recent years have made it increasingly hard to simply participate in the simple act of voting, and one of their preferred tactics to do that is through the implementation of voter ID laws. Today, thankfully, one of those laws was finally struck down by a federal appeals court, although the way that they struck it down isn't exactly the way that myself or other liberals might have preferred. So yes, a unanimous panel of the United States Court of Appeals for the Fifth Circuit, in an opinion written by a George W. Bush appointee, that's very important, held that Texas's voter ID law violates the Voting Rights Act and must, at the very least, be significantly weakened. Importantly, tomorrow is the 50th anniversary of the Voting Rights Act, although it is not in the same sort of state, the same sort of health that it was just a few years ago, thanks to the conservative Supreme Court. And so why does this matter? Well, it matters because those voter ID laws are designed, I believe intentionally, to make it less likely that certain sorts of people will turn out and vote. Those sorts of people might be the elderly, the poor, the very young, or racial minorities. And the Federal Appeals Court, to some extent, agreed with that, perhaps not on the racial angle, which we'll get to shortly. But why is this even a thing? Why do we have the implementation of these voter ID laws? Well, it's because Republican politicians say that they are worried about the scourge of voter fraud, despite the fact that a Wisconsin study found just 7 cases of fraud out of 3 million votes cast during the 2004 election.
7, wow.
7 whole, wait, is that 7 million? No. And none of those 7 cases were the kind of in-person voter fraud that is prevented by a voter ID law.
So out of 3 million votes cast, that Wisconsin study found none.
It would have helped in 0 cases.
In 0 cases.
Well, it would have had an effect, though. I bet there would have been fewer than 3 million votes cast if you had had that law, which is kind of the idea, after all.
And then the Iowa study, put that graphic back up there, the Iowa study found precisely the same thing.
Yeah, it does not matter. It would not affect it. And look, I'm getting depressed reading graphics like this. Sometimes with the same text, I'm sure. We've done it a dozen times. It doesn't seem to matter. We keep showing state after state, study after study, election after election. There is no voter fraud of the sort that can be stopped by voter ID laws. There is no voter fraud that influences in any way an election in America. But despite that, it will continue to be used by conservatives, by Republican politicians, by activists as an excuse to institute these voter ID laws whose actual intention is to make it unlikely that traditionally liberal or traditionally Democratic voters will turn out and vote. But what effect did it actually have? Well, one analysis determined that Hispanic registered voters and Black registered voters were respectively 195% and 305% more likely than their Anglo peers to lack a voter ID in the state of Texas. Again, we're talking about specifically the voter ID law in Texas. Racially, it would have had an incredibly discriminatory effect in practice. This was noted by the Federal Appeals Court. The district court in this case credited expert testimony, additionally, that 21.4% of eligible voters earning less than $20,000 per year lack SB 14 ID, or IDs compatible with the law, compared to only 2.6% of voters earning between $100,000 and $150,000 per year. So again, this is not purely a racial thing, not purely an ideological thing. This is a class thing as well, and it would have made it less likely that poorer voters would have turned out in Texas to vote.
What's frustrating for me about this is that we have to pretend that things that we all know are true aren't necessarily true. And even this judge overall this ruling as it stands now is a good ruling.
It's better than nothing, yes.
It's better than nothing, but it is less than the circuit court judge ruled, and the whole circuit, the whole Fifth Circuit will probably take this up.
Probably. Well, really fast, specifically because in this decision, he rejected the idea that it was intentionally designed to be discriminatory on racial grounds.
Well, that's what I want to get at, because there's a couple of things here. For one thing, there's this article in Think Progress reads, Fifth Circuit determined that the appropriate remedy in this case may not be a broad injunction striking down the law, which is what the circuit court judge wanted to do. Rather, if the evidence in this case does not show that Texas acted with discriminatory intent when it enacted the law. But of course they acted with discriminatory intent. We all know they acted with discriminatory intent. It doesn't necessarily mean that what's in their heart is pure evil. Like, I'll take it, it doesn't mean that they hate black people or hate brown people, but they know that black and brown people vote against them. So they want to keep them from voting. That's discriminatory intent to me. And they, of course, I got it, the legislation, the legislative history, as they look through it, they're not going to say it, But of course,
Probably not.
we all know it. And here I stole your copy, but I know you marked this because it says there that Haynes' opinion vacated the trial court's finding the state lawmakers did indeed act with racial discrimination in mind when they enacted the law. So again, we know that's what they did. That's what the circuit court judge found. But that
And
is
what other states around the country have been doing or attempting to do.
But now this judge at the Fifth Circuit has sent it back down to the district. I've been calling it the circuit judge, but sent it down to the district court judge to say, hey, look at this again. Yeah. And that judge could come up with the same decision, but it's tougher now because the standard has been raised
and it is
in
a
this
very
ruling.
conservative court.
And it's a very conservative court. And in fact, this judge, Judge Haynes, was, as you pointed out, appointed by President Bush.
Yeah. Which, by the way, I love that we say it's less likely that this will continue because it's a more conservative court. It's a more conservative court. They say that they love, the Constitution, democracy, the ability of the people to vote, the government not, like trampling on the rights of the individual. This is specifically a state government making it less likely that you get to exercise your fundamental right, the thing that props up American democracy that I keep hearing and have heard throughout my life is awesome and has been awesome for a couple of hundred years. The conservative court is less likely to allow individuals to vote. And again, look, in an ideal world, to pass a law like this, you should first have to conduct a study into voter fraud and to prove that it is both happening and that this sort of law would stop it. Okay, we don't live in an ideal world, we're not going to get that, fine. But in this case, they get the law first, and even when we conduct the study that shows that the voter fraud doesn't happen, even that isn't enough to eliminate
Right, because
it.
that's what we just talked about. Because this judge here said you got to show, because the law requires now that you have to show intent. When I would think if you keep blacks and Latinos from voting, I don't care what your intent was.
Yeah, what does it matter what the intent is?
Effect
matters.
I don't need, right. But they have raised the standard and made it incredibly difficult, and that was the weakening of the Voting Rights Act. That no law. Now the presumption against states that had previously, the presumption against states that had discriminated in the past would have been that you have to show us that you're not discriminating.
Yeah. This is exactly what that stipulation in the Voting Rights Act was intended to stop, this sort of behavior.
So what's going to happen here is either the Fifth Circuit, the full 15-judge Fifth Circuit, which is pretty conservative, is going to overturn this ruling, or they'll send it back down to the trial judge, and it will be weakened, and it will not. This won't have the teeth that it would have had 5 or 10 years ago. And around the country, until this court changes, it's going to be easier for states that want to engage in this kind of behavior to engage in it, and they'll continue to do it. And for all those people who I like and people I admire and have sat next to on this show, and guys like R.J. Eskow, who will tell you that if there's a decision comes down to Jeb Bush and Hillary Clinton, there's no difference. God damn it, those guys are wrong, and they are wrong, and for no other reason than money in politics, the likelihood of getting judges that will overturn Citizens United and that will restore the power of the Voting Rights Act. Yeah. And I got to tell you, that's enough. It's enough. That's enough for me to have it be a big difference.
Yeah, it would be a good start if nothing else. So again, look, it's a complicated case. It is semi-good news today. And by the way, California also, sort of by vacating what could have been a continuation of a lawsuit, has restored voting rights to 60,000 former inmates, which is, again, a good thing. So good news, I guess.
It's hard.
In some limited fashion.
It's hard to be a liberal because you're like, 60,000 inmates get to vote. Win! You know why it's easier to be on the other side? Because they don't have to worry about issues like that. Yeah. You know what they get to say? I don't want criminals voting.